And I shall now give the floor to Mr. Edward Craven. Mr. Craven, you have the floor.
Thank you very much, Madam President. Madam President, members of the court, it is a privilege to appear before you on behalf of Somalia. In this speech, I shall address Kenya's violations of Somalia's sovereignty and sovereign rights and the related breaches of Kenya's obligations under Articles 74.3 and 83.3 of UNCLOS. It is, of course, well established that a coastal state possesses sovereignty over its territorial sea and exclusive sovereign rights with respect to its continental shelf and exclusive economic zone. The exclusivity of those sovereign rights is expressly reflected in UNCLOS. In respect of the continental shelf, for example, Article 77 provides that a coastal state's rights to explore and exploit the natural resources of the continental shelf, I quote, are exclusive in the sense that if the coastal state does not explore the continental shelf or exploit its natural resources, no one may undertake these activities without the express consent of the coastal state. Accordingly, a state that undertakes any unauthorized exploratory activities in the continental shelf of another state violates the latter's sovereign rights. And this is the case regardless of whether the activities cause permanent physical change. The unauthorized exploration is itself a violation. This is clear from the court's order on provisional measures in the Aegean Sea continental shelf case, which held that, and I quote, seismic exploration of the natural resources of the continental shelf without the consent of the coastal state might, no doubt, raise a question of infringement of the latter's exclusive right of exploration. It is equally well established that judicial determination of a disputed maritime boundary is essentially declaratory rather than constitutive of a state's rights over the maritime areas which are recognised as belonging to that state. As the court emphasised in the North Sea continental shelf case, maritime delimitation, I quote, is a process which involves establishing the boundaries of an area already, in principle, appertaining to the coastal state, and not the determination de novo of such an area. Accordingly, if the court accepts Somalia's position regarding the location of the parties' maritime boundary, the court's judgment will have the effect of recognising existing sovereign rights of Somalia, rather than creating new ones. And it follows from this that if Kenya has undertaken any exploratory or exploitative activities in the maritime space that is found to belong to Somalia, then those activities will, in principle, have violated Somalia's existing sovereign rights and will therefore engage Kenya's international responsibility. Madam President, there is no doubt that Kenya has indeed undertaken exploratory activities in the areas claimed by Somalia. Kenya explicitly accepts that it has done so. After several decades of not awarding oil concession blocks north of the equidistance line, in the mid-2000s, Kenya abruptly changed tack and began to authorise both seismic and drilling activities, knowing them to be in the disputed maritime area. Those activities took place after the dispute between the parties had crystallised. As the graphic on the screen illustrates, in the period immediately prior to Somalia's application to the court, Kenya awarded no fewer than 7 oil concession blocks in the disputed maritime area to at least 5 oil companies. Pursuant to those concessions, several commercial operators have undertaken extensive seismic testing on Somalia's side of the equidistance line. As a result of that testing, those companies have acquired extensive data regarding the nature, location, and volume of the natural resources contained in tens of thousands of square kilometres of Somalia's continental shelf. That data is both valuable and politically and commercially sensitive. Moreover, in addition to seismic testing, at least one oil company licensed by Kenya has drilled a well in Somalia's continental shelf. Kenya accepts that in 2007, the oil company Woodside drilled the Palumbo-1 deepwater well in Block L5 on Somalia's side of the equidistance line. Somalia did not consent to any of those testing or drilling activities. On the contrary, Somalia made repeated and emphatic protests against those activities as soon as it was aware of them and had the ability to object. By authorising and encouraging companies to undertake exploratory testing and drilling in Somalia's continental shelf, and by disregarding Somalia's ardent objections to those activities, Kenya violated Somalia's rights. In addition to unlawfully interfering with Somalia's sovereign rights, Kenya's activities in the disputed area also violated its obligations under Articles 74.3 and 83.3 of UNCLOS. And this is so regardless of where in the disputed area those activities took place, and irrespective of the court's ultimate ruling about the location of the maritime boundary. Now, as the court well knows, Article 83.3 stipulates that pending agreement, the states concerned, in a spirit of understanding and cooperation, shall make every effort to enter into provisional arrangements of a practical nature, and during this transitional period, not to jeopardise or hamper the reaching of the final agreement. Article 74.3, of course, contains materially identical provisions in respect of the exclusive economic zone. In Ghana, Côte d'Ivoire, the ITLOS Special Chamber stressed that the obligation not to jeopardise or hamper the reaching of a final agreement on delimitation is an obligation of conduct, one which requires the states concerned to act, and I quote, in a spirit of understanding and cooperation, end of quote, and I quote again, to make every effort, end of quote, to avoid impeding the reaching of a final agreement. And in light of this, the question for the court is therefore a simple one. Did Kenya make every effort to avoid jeopardising or hampering the reaching of a final agreement with Somalia on the delimitation of the maritime boundary? The answer to this question is plainly no. It is clear beyond argument that Kenya granted numerous licenses that both authorised and encouraged exploratory activities in maritime areas that Kenya knew were claimed by Somalia. And it is equally clear that in so doing, Kenya behaved in a manner that would be perceived by both the government and the population of Somalia as a deliberate attempt to deprive Somalia of its sovereign rights. This was self-evidently likely to hamper the reaching of any agreement in respect of the parties' maritime boundary. Independent reports attest to the detrimental impact of Kenya's activities. One example suffices to illustrate the point. In its 2013 report to the Security Council, the United Nations Monitoring Group on Somalia highlighted the profoundly destabilising effect of Kenya's unilateral activities in the disputed area. The report explained that Kenya's decision to award oil concessions in the contested area had led directly to a dispute between Somalia and the holder of several of those concessions. A dispute which could, and I quote, serve to create further animosity between the government of Somalia and Kenya and exacerbate tensions between Somalia and Kenya that have already been sharpened by political disagreements in respect of other territorial issues. Creating animosity and exacerbating tensions are inimical to the obligations enshrined in Articles 74.3 and 83.3 of UNCLOS. Kenya's principal response to Somalia's case has been to assert that the dispute with Somalia did not crystallise until 2014. As Somalia has already explained, that position is completely wrong and is contradicted extensively by the documentary record. As Professor Sands has explained, since as far back as the late 1970s, Kenya was aware that Somalia claimed an equidistant maritime boundary. Somalia never disavowed that position. Kenya's claim to the contrary is directly contradicted by its own statements, including at an earlier phase in these proceedings. In its preliminary objections, Kenya acknowledged that the dispute already existed at least half a decade before 2014. According to Kenya, it was only in 2009 that Somalia first disputed Kenya's 1979 EEZ boundary. And similarly, the Memorandum of Understanding, which the parties concluded in 2009, expressly referred to the existence of a maritime dispute and contained no fewer than 11 references to the dispute or disputed areas. Kenya's principal argument is thus fatally flawed. Kenya's other line of response is to assert that no violation can occur where the activities in question are merely transitory in character. This argument also lacks merit. Article 77 of UNCLOS prohibits all unauthorised exploratory activities in Somalia's continental shelf. It draws no distinction between unauthorised activities of a permanent or transitory character. A temporary interference is still an interference, and particularly where it results, as here, in the permanent unauthorised acquisition of sensitive data concerning Somalia's maritime resources. Secondly, the case law cited by Kenya does not establish that Articles 74.3 and 83.3 can only be violated by activities that have permanent physical effects. Nor is there any mandate in the language of those articles for such an interpretation. What matters, as the Special Chamber recognised in Ghana, Côte d'Ivoire, is whether Kenya has made every effort to avoid jeopardising or hampering the reaching of a final agreement with Somalia. In the context of the existing dispute, Kenya's decisions to award oil concessions in maritime areas claimed by Somalia and to permit and encourage the carrying out of extensive exploratory tests in those areas plainly fell short of that exacting standard. And thirdly, and in any event, Kenya concedes that not all of the activities in question were transitory. On at least one occasion, a well was drilled on Somalia's side of the equidistance line. Thus, even on Kenya's approach to the law, the standard enshrined in Articles 74 and 83 was indisputably breached. Madam President, the consequences of Kenya's unlawful acts are straightforward. In accordance with international law, Kenya is obliged to cease its wrongful acts so as to respect Somalia's sovereignty and sovereign rights. In particular, it must cease to award any oil concessions north of the equidistance line, and it must annul such concessions as it has purported to grant. Although Somalia is entitled to substantial reparation from Kenya. In the spirit of amity and neighbourliness, which Somalia hopes will characterise the parties' future relationship, Somalia does not pursue a claim for reparations for past wrongs. Instead, Somalia asks the court to do just three things. First, to affirm unambiguously the existence of Somalia's rights. Second, to recognise the violations of those rights that have occurred. And third, to order that Kenya shall cease its wrongful acts and take all necessary steps to terminate any measures that violate the sovereignty or sovereign rights of Somalia. Madam President, Somalia is one of the world's poorest countries. Following years of civil conflict and humanitarian disasters, Somalia's maritime resources are one of its few valuable assets. Unfortunately, they are also among its most vulnerable. Somalia has brought this case before the court in order to obtain vindication of its sovereign rights over those resources, which are critical to its future development and to the future security and prosperity of its people. As the preeminent guardian of the international legal order, Somalia looks to this court to ensure that its sovereign rights are effectively protected for the benefit of all of Somalia's people and in accordance with established principles of international law. Madam President, members of the court, thank you all very much for your kind attention. In accordance with our understanding of the statement at the start of this session, Madam President, this concludes Somalia's presentation today.
I thank Mr. Edward Craven, whose statement does bring to an end today's presentation of Somalia's oral arguments. I wish to recall, as mentioned at the opening of today's session, that the court yesterday received a letter from Kenya and a response from Somalia that present the possibility that the oral proceedings will continue beyond today. The matter is currently under consideration by the court. Once the court has taken a decision, the registrar will inform the parties as to the further conduct of the proceedings. For this reason, the reading by Somalia of its final submissions will be deferred to a later date.